Hello everyone. This is Kara Cowan Watts with Cherokee 411 by Kara. Today we have with us former Chief Chad Smith, who is also a Cherokee historian and an author. He has several books out, but my new favorite is his latest book that he self-published, and you can purchase on Amazon. If you go to Cherokee 411, you can see the link to the Amazon store to purchase his new book. But he's going to talk about just a small portion of that book plus more today. And we're going to dive in to the issues around McGirt and give a little bit of a historical, legal, contextual background for those folks that maybe haven't been following Oklahoma news about how McGirt has impacted. Now, I believe we're on 6 tribes. I don't think we have a seventh. I'm trying to remember. I know it was the 5 tribes plus Quapaw, maybe more. But we're going to hear from Chad today, and he's going to give us a historical background. We're going to have three objectives: historical background on the jurisdiction, kind of what does jurisdiction mean? How does it relate to you as an individual Cherokee Nation citizen, United Kituah Band system here, citizen here in Oklahoma? Or how does it impact people like my husband, who's a Wyandotte Nation citizen that lives inside the Cherokee Nation? Then the idea that McGirt's limited to the criminal jurisdiction, and then how far will it go? Will we have taxation? Will we have civil lawsuits? How about eminent domain? We're going to visit a little bit about all these issues. And so it's now time to hear from Chief Chad Smith about this. Thank you for being on with us today, Chad.
Thank you very much. McGirt was a bit of a surprise several years ago when the Supreme Court, in a narrow decision, basically held that the boundaries of the Cherokee Nation had not been disestablished. So if we go back to really basics, we go back as far as the Louisiana Purchase in 1803. The United States purchased millions of acres from France, paid $15 million. France transferred to the United States the highest title that countries or nations can do, basically by treaty and by fee patent. The United States got title to the Louisiana Purchase and incorporated it into the United States. Well, of course, the Cherokees lived for many hundreds of years in the southeast United States, and it held title recognized by the world to its territorial treaty hunting areas. So with the effort of removal in 1835, of course, that led to the Trail of Tears in 1838, got to Indian Territory, and under that treaty, what we call now the Cherokee Nation proper plus Cherokee Outlet was transferred to the Cherokee Nation. That was commemorated with a fee patent, and that fee patent is on parchment, and it hangs at the Heritage Center, Archive Center. It's a meet and bound description of the boundaries of the entire Cherokee Nation, all 14 million acres. That's important because the United States transferred its entire title and interest to the Cherokee Nation just as it got from France. Of course, Indian Territory was part of Louisiana Purchase. So that fee patent commemorates the boundaries and the territorial jurisdiction of the Cherokee Nation. Well, that continued for 60, 70 years until the United States wanted to assimilate the Cherokees through an allotment policy. So they decided, well, going, instead of take Cherokee Nation territory from tribe, we're just going to mandate the Cherokee Nation take its title, break it up into pieces, and issue a fee patent or a land patent, each of its individual citizens, allot the land, give everybody a pro rata or effectively their fair share of the land. What's important in that is that Cherokee Nation did not transfer its right, title, and interest to the Cherokee Nation back to the United States. It was compelled and transferred the tribe's interest to the territory of the Cherokee Nation, individual Indian. So those boundaries of the Cherokee Nation were never disestablished. They still existed. Only the difference is that proprietary interests of the Cherokee Nation in that land transferred to its citizens. I was at a conference once with the Oklahoma Independent Petroleum Association, who historically had been at odds with the tribes. And one of the guys said, "What do you guys want to put up a reservation in the boundaries of the Cherokee Nation?" Of course, the proper response is, "Why do you guys want to put up a state around our tribal territories?" Because we were a republic in Indian Territory long before Oklahoma. And so what was history reflects very quickly is that those boundaries of the Cherokee Nation, that fee patent that meets and bounds description, never been disestablished. Well, that lay dormant for 70 years because of bureaucratic imperialism by the Bureau of Indian. So now we get to the 1990s, the 2000s, 2020 time period, and McGirt is charged by state court for a serious crime. He asserts the state has no jurisdiction because the Cherokee Nation, or the Creek Nation in his instance, never transferred governmental interest to the state. That fee patent meets and bound description had never been disestablished. And so whatever the Cherokee Nation had in 1906 for the Five Tribes Act that compelled allotment, Cherokee Nation still held, except for the proprietary interest, land interest, transferred to individuals. Nobody ever wanted to believe that. And actually, in 1998, I asserted that same theory that the Cherokee Nation boundaries had never been disestablished in a fishing case up in Noah. The Oklahoma Court of Criminal Appeals rewrote the record and ignored it. That's why McGirt was so interesting. Is said, you know, guys, tribe didn't transfer criminal jurisdiction over members back to the state or to the United States. Still maintains it. Tell us you can show us how the tribe transferred its governmental interest to criminally prosecute its own members. They still have it. And that's what happened, is that, and then there was a flurry of excitement because keeping the boundaries intact, it's a lot. It was history, and it was a law. What was really pretty fascinating is how Oklahomans and other folks just were shocked that that could ever happen. They'd never read the treaties. They never read the enabling acts. They never read the 1905 provisions for allotment. They were just shocked. They shouldn't have been. They taught the history for the 50 years prior. They would have known this should have been coming. The other big shock is that you had judges that had enough backbone to make a decision. 60 years prior, would not have found a judge or a series of. So here's the point. With McGirt, the tribe and the federal government had jurisdiction for criminal action. What people can remember is that crime is not an offense against an individual. A crime is an offense against the government. If you read the complaints of information, it'll read something against the peace and dignity of the laws of the Cherokee Nation, against the dignity of the laws of Oklahoma, against the peace and dignity of the laws of the United States. The victim criminal case is really just a witness. So what is prosecuted is the offense against the state, against the government. So McGirt had authority for tribes to reassert criminal prosecution over its members. The state now. So now the question is that you had to go back and what cases were, you don't have jurisdiction. Criminal prosecution is null and void. So you had all these cases that were in the queue, been sentenced. What happens to those folks? A lot of the interest and energy was invested. How do we go forward? Who prosecutes these? Which cases does the state prosecute? Which cases does the tribe? What cases feds? And the way it's shaken out is that if you're not an Indian, McGirt doesn't apply, pretty much. There's crimes, victimless crimes and others that may. But here's where we're at, is that the feds have the authority with the tribe to prosecute serious crimes, arson, rapes, murder. The problem with tribes prosecuting those serious crimes, they're limited to 3 years in prison by federal law under the Indian Civil Rights Act. It's a very serious crime. Feds can meter out greater punishment. So the majority of run-ins with the law are misdemeanors. Then in smaller classes, the felonies, serious crimes. And then there's sort of a gray area of things that you'll find like in traffic tickets. Is that a crime or is that a civil or regulatory offense? And it gets a little bit more murky there. But if state or the tribe can put you in jail and take your liberty away, it's criminal prosecute. So today we go ahead.
Okay, so I just want to make sure. So we had the historical background around jurisdiction and the fee patent with the metes and bounds description, um, and the transition from statehood after Cherokee Nation, statehood, but Cherokee Nation still exists. And we get to McGirt and the U.S. Supreme Court decision where then crimes or offenses against government can are still prosecuted by either the Cherokee Nation, Muskogee Creek Nation, Choctaw Nation, Chickasaw Nation, and Seminole Nation, the 5 tribes where that applies. And to your point, you've got lesser crimes, misdemeanors, you've got felonies, you've got serious violent crimes, and then you have the Indian Civil Rights Act, which limits, I'm doing active listening, Chad, making sure that I caught all this. So,
you're doing well.
okay, very good. So then you have the Indian Civil Rights Act, which limits it. We were only up to 1 year per offense, right? And then murdered the VAWA, the Violence Against Women's Act, which some folks may only interpret as like the murder to missing Indigenous peoples work that was done on the federal case. That was the only time the Indian Civil Rights Act has been amended, right, or impacted. And so that allowed, like for us, example, Cherokee Nation or the United Kituitt Band to go to 3 years for some offenses. Is that correct? Okay. I just want to make sure I was caught up with you because you just gave us a lot of information, which was really good. All right. So then we go to criminal, and I think I interrupted you, but I wanted to make sure they understood that we're limited if the tribe prosecutes versus what the federal government prosecuting. If they're a victim of a violent crime and they are insisting that somebody get a tougher sentence, so to speak, it would have to be through the federal government to prosecute, probably.
Yes.
Okay. And that's where you would go to jail for a longer period of time.
Yes.
Okay. All right. So I interrupted you. So we've got the historical background. We've talked to, is that all you wanted to share on criminal?
Um, we need to reassure people that if a crime is committed, there's a government that can prosecute it. There's not this idea of lawlessness. Somebody commits a crime, Indian or non-Indian, in the boundaries of Oklahoma, there's a government that can prosecute it. It can either be the state, tribes, or the feds. And with criminal law, even though it's statutory law, it's almost become a common law. Everybody, all three governments have crimes on the books for assault, battery with a dangerous weapon, arson, burglary, manslaughter, DUIs. So any offense committed, there's a government that can prosecute it. Where the rub is today is the transition as to what occurs in the five tribes and maybe the cooperative because of Cherokee Nation boundaries not being disestablished is who tribe or the feds prosecute it.
Are
Feds
you
are very
referring to the Department of Justice lawsuit against the Rogers County, Mays County District Attorney Matt Ballard and the Okmulgee or Creek Nation District Attorney or Assistant DA? Excuse.
exactly. The feds are saying, states, you can't prosecute these folks, these crimes. Uh, really, what I think the state is doing is trying to nibble back or claw back some of the jurisdiction criminal cases for themselves. Now, this is really reflective of the time in 1991. There was a case that shocked everybody. It occurred at Greasy Ballpark over in Airedale County, and the state prosecuted Cherokee on trust land. The federal court ruled that state you can't prosecute an Indian on trust or restricted land. That blew everybody's mind away. Now, what are we going to do? We don't know what is Indian trust property. We don't understand what restricted property is. If a policeman goes out to Bell, which house is Indian country, which house is not. Created all this fervor. Well, there's an easy remedy to it. Cross deputize. Policeman goes out, whether it's Cherokee or state or FBI, they make the arrest, they do the investigation, they turn it over to the prosecutors, and the prosecutors can decide what court it goes to. So that grew cross deputization, and within a few years, and well accepted. But what it demanded is everybody coordinate their effort and coordinate their resources. And the Cherokee Nation was able to bring more resources to eastern Oklahoma. So it actually worked out fairly well. So now you've got the same thing, except whose court belongs. Policeman arrests somebody, turns the paperwork over to the prosecutor. Now the prosecutors have to decide which court to go in. And so the Department of Justice, as you mentioned, is that dispute. And the long and short of it is that they actually negotiate a cooperative way to administer criminal justice in northeastern Oklahoma or Indian Territory. Uh, the parties made that their ultimate.
Okay. Boy, this brings a bigger question that I didn't ask you before this, so I'm going to throw this at you. So there's concerns. Some of these are my own concerns, but concerns in the community that there are elected officials, politicos that are going unprosecuted in the Cherokee Nation by our current administration, current court system, and that the records in the state records, which is we know as oscn.net, have actually been removed. So there's no records of DUIs, drug possession, this other stuff that's going on, and there's no prosecution, and these people are still running loose those are my terms, in the Cherokee Nation, driving around, probably not sober, even in the middle of the day, that's the lawlessness concern. It's not because we can't do it or aren't capable of doing it, but that they're choosing not to, maybe for political reasons. Um, they don't feel like there's any oversight. That's where that's coming from. Chad, do you want to talk about that for a moment, or like how does that even work that they can't do that? Like I know even for the court records that we've done, I can't find court records on our tribal website, and that's frustrating in terms of transparency for government.
Well, actually, our court records are, they need to be brought up to date, but their criminal cases are, there's a place to find them. But the real question is, it's not what is the law of jurisdiction here. The real question is political question. For those charged with the duty to prosecute crime, faithfully fulfilling that duty. If you go back in Oklahoma history to its early days, I want to talk about lawlessness. You go to Little Dixie, you have lynchings and hangings, and nobody gets prosecuted. You say the same thing about the feds. They won't prosecute somebody because of their statute. Just look in the last few weeks, major criminal cases against elected officials are dismissed because one political party has control of prosecutorial systems. So what the Cherokee Nation is facing is the same thing as other governments have faced, one of political accountability. Because criminal justice systems aren't working well in the Cherokee Nation. It's a political decision how to manage that, put resources to it, call people to accountability. And there's some crimes that just are not prosecutable, like the feds. Unless they've got 99% certainty they can get a judgment, they won't prosecute. State courts, they'll file lots of cases and hopefully they can make a case until when it comes up for jury. Plea bargains and said, the feds, they don't necessarily plea bargain. They sit you down and say, here's your case, you take it or leave it. And there's not a lot of negotiations. They don't go to trial. It's state court. And I was a state prosecutor. File a case, arrest them, they're in jail. Hopefully we're going to be able to make the case by the time it goes to trial. And then during that period of time, you can judge strength of your case. That's where you can start active negotiations. Or agree. 2 years or 16 months. Deferred sentence, I mean, it's lots of mechanisms. With the tribe, it has to take its responsibilities seriously, but the resources, and people have to understand that some crimes you just can't prosecute, but it's just not there. Some other legal impediment to it,
Okay,
but it is good. It is
so I
good
have
that
a couple of
frustration.
follow-ups then. What was the deal? What were you saying about frustration?
I understand the frustration is good because that's the motive. Get good people into office, have them take accountability for the criminal justice.
Okay. So how does the recent O'Brien case ruling where the Osage Nation citizen, I think in Creek Nation, was it a traffic ticket or DUI, said that decided that the Creek Nation doesn't have jurisdiction to prosecute a different tribal citizen? Or was it that the county could prosecute? How does that also weigh in on determining who has jurisdiction?
Okay, so do the feds have jurisdiction? Probably. I don't know if they have DUI as one of the crimes that they can prosecute. Indian country. And if you look at the jurisdictional issue, well, this is a good point. Distinguish what jurisdiction. Jurisdiction is the authority of the government to act in individual citizens. It is what can the state do to individuals. The ultimate protection guideline for that is constitutions and statutes. So you have three kinds of jurisdiction. One is personal jurisdiction. Is that person subject to the power of the government or that particular government? For example, if you're working in Nebraska, earn all your income in Nebraska, but you have a home in Tulsa, does the state have authority to bring you in for a tax filing? Can they personally take you and bring you back? Another kind of and personal jurisdiction is basically, are you within the territory of the government? Have some other nexus. The other one is territorial jurisdiction. What is the boundaries that you can assert your governmental authority? And that's where McGirt came in. McGirt said it's for tribes, it's just not trust or restricted land. It's the entire boundaries for the Cherokee Nation a patent. Then the last kind of jurisdiction is subject matter jurisdiction. Has the government been granted the authority to exercise their authority? And that's what criminal jurisdiction is, it's subject matter. Are there books on the crimes on the books that the tribe or the state can prosecute? So let me give you an example. We had a tribal citizen that was charged with embezzlement. Tribe statute when embezzlement was poorly written when it was transferred from state language. I think the tribe codified its stuff again in 2014 when they brought it in, and they're called orange books, and it's online. But if you look at the language of the embezzlement statute, it only provided criminal prosecution for the property embezzled less than $50. Less than $50. But when they charge this tribal citizen with embezzlement for thousands and thousands of dollars of basically legitimate business, they didn't have subject matter jurisdiction to do that because they were limited to less than $50. And that's a tribe or any other government's authority. For example, at one time, there was no statute on the book to prosecute child trafficking under 16 years old. Passed a law and became illegal. So that's subject matter. So there may be some things that we don't like. They're not crimes.
And that's because the tribal council has not enacted laws to make those crimes, those issues crimes. That is very helpful, Chief Smith.
And the other way, I mean, that's actually part of sovereignty. Actually, the tribe can pass laws that really make a lot of common sense and other governments won't do. Like maybe a law that will protect elected officials from harassment on the internet. We say if a tribal citizen says something about you or looks at you cross-eyed, we can criminally prosecute you for harassment. In other jurisdictions, that's not criminal behavior, even though it may not be tasteful.
Which you're bringing up an actual real world example inside the Cherokee Nation, the way I read the law. That's really what they've done.
Well, I mean, you can read the law different ways, but the reality of it is how they've used it. Legitimate.
That's probably its whole own episode, Chad.
The
Okay.
point being is that you can pass criminal actions, criminal prohibitions for bad acts. We cannot pass criminal actions for bad acts. That's also a political decision.
Okay. This is very enlightening. I have one more question before we go on to the last component of this, before we talk about taxation and civil and such. So, how many jurisdictions can either of us, as Cherokee Nation citizens, depending, I guess, on the law and that we're inside the Cherokee Nation, can we be prosecuted by more than one government for the same act?
Yes, you could be prosecuted by the feds and the tribe, same act.
Okay. Is there a potential that also the state could prosecute us even for the same act?
No.
Okay. So I want to explore the O'Brien case and some of the others on a separate episode of when you have time, and we'll get to that. But let's get to the last part. How far, I mean, I don't know that either of us have a crystal ball for the US Supreme Court or the other courts that'll rule, but talk to us a little bit about taxation and civil and eminent domain, because McGirt is only limited to criminals so far. How far will this go potentially?
Well, there's cases pending with the Oklahoma Tax Commission, go to the Oklahoma Supreme Court. Sometime it may be removed to federal court. Can the state collect state income tax of tribal citizens living within our boundaries? That's a taxation. That's it. Can the state assert regulatory jurisdiction, taxation jurisdiction over tribal members? Can the state require me to, here's another one, can the state prosecute you for not having insurance on your car? Can the state enforce zoning restrictions in your area? You're out in the country, your house burns down, it's an eyesore, it's an attractive nuisance against the zoning requirements of that municipality. Can the municipality come in and make you clean it up? So all those things, they reach far and wide. That's why the different tiers of jurisdiction matters. And a lot of those things, and actually the Supreme Court said this in the McGirt case, they recognize the tribes and the states have a number of compacts, hundreds of compacts, resolve conflicts over jurisdiction in child welfare, gaming, motor fuels, tobacco. Supreme Court says we're not going to resolve all those things for you. You know how to negotiate them. We encourage you to resolve them yourself by agreement rather than have the legislature, Congress do it for you. That's really one of the messages sent. And that's really where we're at. I always like the adage, diversity creates opportunity. So if you have well-meaning people, understand a common goal, and combine and negotiate systems that everybody benefit. And that's really where we're at, because there's no simple answer to how far McGirt gives tribes authority or acknowledges their.
And really, I will always be the student of tribal government and sovereignty in our history. But when I think about what you just shared with us, I, as a Cherokee Nation citizen, as a former elected leader, do not want a court or judges or the Congress, US Congress, to decide what our interpretation of sovereignty. is like either. And that's what I hear. I mean, that would be the next step. If we don't have political folks that are in leadership that are willing and able to come to the table and negotiate a shared framework for our shared economy and for our safety. So
And it
that's what I
takes,
heard you say.
it's right. And it takes somebody on both sides, not only the
Yes.
tribe side, but the state side. And sometimes it takes the Oklahoma delegation to be there to ensure that things move along. So there's adversity, but there's opportunity. I remember Governor Keating when I took office, 1999, and he called me down and was delighted to go see him. He says, "You know, we'd much rather negotiate than litigate." That was at the time of the smoke shop, Quick Trip, and all those folks who pulled their lobbyists out and beating up on Indians, figurative. So that's really the spirit that really has to prevail. Uh,
Wow. Chief Smith, this has been wonderful. I know we're going to take a break before we get into the United Katua Band history, but I want to thank you for really laying out this contemporary history within a historical context that we as Cherokee Nation citizens today understand the economy that we live in and the government that we live in, and the opportunities we have when we go to the polls to vote for, not just our elected officials of the Cherokee Nation, but our elected officials across the state of Oklahoma and those Supreme Court justices that we put on the ballot. I mean, there's a lot of things you've given us to think about. Did you want to share anything else?
yep. When you talk about adversity, look at it, the indexes where Oklahoma ranks in education, incarceration, economy. Every index of healthy government and a healthy economy, the tribe, the state of Oklahoma is 47th to 50th. A lot of adversity, a lot of opportunity, and it doesn't have to.
And like you, I see it as opportunity. Now, before we close, and I say thank you to our listeners, you talk about this in detail and you have it indexed in your book, right?
Yes.
Do you, can you, those that have bought your book and they're reading it or they're going to read it, what chapters, do you recall what chapters that they could pick up more on McGirt and our historical jurisdictional, our history of our jurisdiction? Or is it just throughout the book?
Actually, if you read chapter 6, talks about the period of time between statehood and our 1975 Constitution. A lot of
Okay.
these issues are bubbly laid in the foundation during that time. And then the next chapter is numbers 8 is about the 1990 Constitution. So the 75 Constitution took 70 years of bureaucratic imperialism, horrific circumstances, poverty, uh, oppression, all that stuff. Able to finally begin a resurrection, revival. And then the 99 Constitution, it's actually to me the epitome of great government. Almost warring factions came together after tremendous internal conflict and produced a constitution. It's really pretty powerful.
So I didn't have the honor or pleasure of being part of the Constitutional Convention at that time, but I know during my 12 years on tribal council, I would often go back to the meeting minutes and I would call up Jay Hanna, who chaired the Constitutional Convention, or I'd talk to you or Troy Wayne Petit or the other folks that were at the convention, and I would ask questions and I would read. And that is fascinating all by itself, our Constitutional Convention minutes. So during that time. Chief, thank you so much. We're going to take a quick break before we get into the United Katua Band. And um, just to give you context, we're inviting other people on for other perspectives, right, on all of these issues. But we're excited to hear from you and get a historical background before we delve into the diverse opinions on the issues that we're going to be talking about. But up next is the United Katua Band and the history of their government. But Chief, thank you again for your time today. Wado Nagad, thank you everyone. We appreciate you being on to listen to Cherokee 411 with Kara. Wado, and have a good day.
Join the conversation. Discover stories and insights that matter to you. Subscribe to Cherokee 411 with Kara and stay connected with independent media, real, relevant, and unfiltered.